Welcome back to Insights Delivered, brought to you by HRDelivered. This is your weekly HR guidance, compliance support, and people-first strategies for growing teams. Today, we're diving into labor law updates going into 2026. There's been a steady increase in changes across states, and many of them affect how employers manage leave, payroll, and job postings. And what's interesting is that these updates aren't isolated. They're happening across multiple states at the same time, which makes compliance more complex, especially for employers operating in more than one location.
Exactly. And even employers operating in a single state may still be affected if they have remote employees or are hiring across state lines.
That's a good point. A lot of businesses assume compliance is location-based, but the workforce has changed and the laws are catching up to that reality.
Okay, Eric, let's start with family and medical leave because this is one of the most active areas of change going into 2026.
Right? We're seeing states expand unpaid, FMLA-like leave in several ways. Some are lowering the minimum employer size required for coverage, which brings smaller organizations into scope. Others are expanding the amount of leave available beyond the traditional 12 weeks that many employers associate with federal FMLA.
And states are also adding new qualifying reasons for leave, which is something employers really need to pay attention to. That includes things like genetic testing, broader caregiving responsibilities, and newly recognized medical conditions,
which directly affects eligibility determinations. Employers can no longer rely on the same narrow definitions they may have used in the past. It also affects notice requirements and job protection obligations. Employers need to understand when leave is protected and what that means for reinstatement. And this is where documentation becomes critical. Having clear policies and consistent processes helps reduce confusion for both employers and employees.
That's just on the unpaid side. On the paid family and medical leave front, we're seeing continued expansion as well. As of now, 13 states and Washington, D.C. have state-run paid family and medical leave programs. These programs are typically funded through payroll taxes, which means employers need to manage deductions and reporting accurately. And while the structure varies by state, most programs cover bonding leave, medical leave, and caregiver leave.
Going into 2026, we're also seeing state-specific expansions that employers need to be aware of. Colorado is a good example. They're adding up to 12 additional weeks of paid leave specifically for NICU-related care. That's a significant change, and one that requires employers to revisit how their leave policies align with state programs.
That's right. Rhode Island is another example. They're expanding temporary caregiver insurance from 7 to 8 weeks. And Washington is broadening eligibility and strengthening job protections, which affects how employers track leave and manage returns to work.
All of this adds layers to payroll administration, policy management, and employee communication. Communication is especially important. Employees are increasingly aware of paid leave programs and expect accurate information from their employer.
That's true. Employers need to be prepared to explain how state programs work alongside company policies.
Let's move into pay transparency, because this is another area where changes are accelerating. We've seen 7 states and several cities enact new pay transparency laws in 2025 and into 2026.
States like Illinois, New Jersey, Massachusetts, Washington, and Delaware are all requiring some level of pay disclosure.
Most commonly, that means including pay ranges in job postings. But it often goes beyond that. Many laws also require descriptions of benefits and total compensation. And there are record retention requirements tied to these disclosures, particularly around job titles and wage history.
In some cases, employers are also required to report pay data to state agencies, which introduces additional compliance steps. California employers, in particular, should be preparing for changes effective January 1st, 2026. California now requires job postings to include a good faith estimate of total compensation. That includes base pay, bonuses, stock options, and a benefits breakdown. Employers must also retain job titles and wage history records for 3 years. And these requirements apply broadly, meaning employers need to ensure consistency across postings and documentation.
California is also implementing minimum wage and exempt salary updates, which impacts employee classification. That means employers should be reviewing exempt and non-exempt classifications now, not waiting until the end of the year. Another area that's easy to overlook is pay stub compliance.
Yes, and these updates can create issues quickly if payroll systems aren't properly configured.
Oregon is implementing new requirements starting January 1st, 2026. Employers must provide detailed written notice at the time of hire outlining earnings and deductions, and those notices must be updated annually.
Ohio also has an update effective April 9, 2025. Ohio now requires expanded pay stub content, including hours worked and overtime for hourly employees. These requirements are particularly important for employers with remote or multi-state teams, because one payroll system may need to meet multiple state standards simultaneously,
which increases the importance of regular audits and system reviews.
So when employers ask what they should be doing now, the answer really comes down to preparation and review.
First, employers should review and update job postings, employee handbooks, and wage policies. Second, they should ensure payroll systems are aligned with evolving requirements. That includes deductions, disclosures, and reporting obligations. Third, employers should work with their HR consultant to confirm compliance in every applicable state, especially if they operate across state lines or have remote employees.
These updates may seem technical, but they directly affect compliance risk and operational efficiency.
They also influence employee trust. Clear policies and accurate information help set expectations, and staying proactive helps employers avoid last-minute adjustments or penalties.
This conversation is based on an article from the HRDelivered blog. For the full breakdown and more practical HR guidance, visit hrdelivered.com/blog.
And if you have questions about how these 2026 labor law updates apply to your organization, reach out to your HR Delivered consultant. Thanks for listening to Insights Delivered. We'll see you next week.